Rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All we have cause to plead. Draw near, and you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. Before we turn to the first case on the docket today, I want to take this occasion to recognize that we have three new justices on the bench with us today. This is really an unusual event in the life of our court when three new justices are coming on at the same time. But we're delighted. On behalf of the old justices, which is an apt description in more ways than one, I want to welcome the three new justices. All three of them have had distinguished careers in public service. Justice Lagoa, Justice Luck, and Justice Muniz have distinguished themselves in their career, and we are so delighted to have them join us as colleagues. Now, in due course, they will be announcing dates for their investitures, and we will be able to recognize them more fully and appropriately. But I did not want to let this occasion pass without saying a welcome to them. I can tell you this, they've not been on the court long, but they have, from the very start, gone about the work of the court with great energy and dedication, and I am very much personally looking forward to working with them over the years to come. All right, welcome. Now, we turn to the first case on our docket, which is Florida Industrial Power Users Group versus Brown.
Good morning. May it please the court, I'm John Moyle with the Moyle Law Firm, and I have the privilege to represent the Florida Industrial Power Users Group before you today. I've asked to reserve 7 minutes for rebuttal. The key issue before you today is whether the Florida Public Service Commission erred when they approved nearly $1 billion in new capital costs for solar generation projects that FPL proposed without conducting a prudence review. FIPUG argues that they were obligated statutorily and through case law and through their precedent to conduct a prudence review, and they failed to do so. I don't think we have a disagreement about whether indeed they conducted a prudence review or not. They did not. But the argument is buttressed by Section 366.061. It's a statute that this court has looked at, but I thought I would just briefly call out the statute with respect to what it says in pertinent part. And it says that for money that is honestly and prudently invested by the public utility company in such property used and useful, that the commission has to conduct an investigation and determine that the investments are indeed honestly and prudently invested. The use of the word prudence has been picked up by this court. I can refer you to the Sierra Club case that you recently handed down, where you said, quote, "It is from this statute, 366.061, that the commission derives its prudence standard, which it applies to ensure that the recovered costs result from prudent investments."
Let me ask you how the settlement agreement enters into the analysis here. Is the prudence review required by the settlement agreement, or is it your position that the settlement agreement has no application?
Sure.
Address that.
And the settlement agreement is not what is before this court today, as you know. That was from a separate order The court applied a
But isn't all this done pursuant and in accordance with the provisions of the settlement agreement?
We take the position that the settlement agreement, it had 167 or 168 items in it. One of them related to this issue. And it was something that was set forth in the settlement agreement in some very broad terms, but it envisioned a subsequent rate proceeding.
But the framework that was followed here was established in the settlement agreement. Isn't that accurate?
The settlement agreement said, here's what in the future you could look at with respect to a future solar project, and identified three things. Is the project cost effective? How much money will it cost? And what percentage rate increase would that require? That was in a settlement agreement that was approved by the commission.
Well,
it didn't have anything about prudence, and we take the position that you can't, in a settlement agreement, override the legislature and their prerogative as to a prudence review. I mean, essentially, we take the position the settlement agreement was an apple and this is an orange, because this is where the rubber, they're in, and they filed testimony and they said, we want approval for an additional $1 billion. And the premise of our argument is the power is not needed for generation reliability purposes, and that's something that should be considered in a prudence review. A prudence review is a broader review, and we tried to argue below, and we would argue before this court, that need is paramount in considering whether to have ratepayers pay this kind of money for projects that we contended were not needed when you look at reserve margin, and I can get into the details if you wish.
You described the settlement agreement generally, but in specifics, it provided a procedure for approval of cost recovery for a certain amount of solar capacity. Is that correct?
That's right. It said 1,200 megawatts over 4 years.
And so it provided the amount, the timing, and it also provided the standard by which the commission would review those for cost recovery purposes. Is that correct?
That is, and I think that was the three things that I hit on: the cost effectiveness and the money and the rate increase.
So if the settlement agreement provided the procedure and the standard, and that procedure and that standard were followed, then wasn't the opportunity to challenge that and make the arguments that you're making now when the commission approved the settlement agreement and when we affirmed the approval on appeal?
Respectfully, no, for a few reasons. What was in that settlement agreement gave FPL the ability to come in and seek that recovery, to come in and file a future petition. It contemplated a future petition where they would come in and they would provide how much money they're looking for. It would provide the details. And so that was not the right order to appeal the settlement agreement.
Did you have an opportunity to challenge those things then?
Well, we didn't have the details that we have now with respect to...
You had the details of what the procedure was going to be, and you had the details of what the standard was going to be. And if your argument was that that's an inappropriate procedure and an inappropriate standard for determining the cost recovery for that amount of capacity, or that that amount of capacity was not needed, then why wouldn't you raise those issues in that proceeding?
We for a few reasons. One, it wasn't right to be raised at that point in time, and we've cited that in our brief because it was an option for FPL to pursue it. They had the option. They weren't required to come in and seek this. Things happen in the utility world. It's 1,200 megawatts over a 4-year period. We still don't know whether they're going to come in and seek the last remaining portion or not. It's a series of things. And also, the commission has previously said that they couldn't be bound by a contractual agreement, that they had to follow the statute. So we weren't presumed to know that the commission, when they were reviewing this later, was not going to apply a prudent standard. They should have applied a prudent standard, and they could have looked at the contractual provisions and said, here's what parties agreed to contractually, we'll apply that, but we have a statutory obligation to apply a prudent standard, and that's what they should have done. And to take the contrary position...
It just seems like it would have been very easy to raise that point in the commission and say, well, this procedure does not, and the standard doesn't contemplate a prudence review. It says you get this amount and you get to cost recovery it if you ask and if you meet this standard. So if you felt like that was an inappropriate standard, all you had to do was object, and then if the commission agreed, they could have put in there that prudence also has to be determined. But it just seems to me that after that has been approved and then it's followed exactly as it's set forth, it's a little too late to raise these issues.
Yeah. Respectfully, we would disagree, because if you follow that train of thought and that logic, it is a green light for parties to write in a settlement agreement their view of the world, their policy statements, and disregard what the legislature would say. Again, we had no advance knowledge that the commission was not going to follow their precedent and their application, of prudence. And if I could just...
Excuse me, can I ask you a question? So, but if the settlement agreement itself clearly embodied provisions that were contrary to law, wouldn't that be a basis for challenging the settlement agreement?
They weren't contrary to law, they were silent as to law. It didn't say anything with respect to whether a prudence review would be conducted. So I think it's fair for a party to assume that they would, particularly if I could. There was a case prior, a GTE case, where the commission said, and if I could just read this, we do not possess the legal capacity of a private party to enter into contracts covering our statutory duties. Indeed, we cannot abrogate, by contract or otherwise, our authority to assure that our mandate from the legislature is carried out. As a result, we may not bind the commission to take or forego action in derogation of our statutory obligation. The prudence standard when you're seeking new rates is very clear in 366.06, as I've said.
Counsel, what overlap is there between the prudent standard and the public interest standard, which was clearly found in our prior decision and by the commission when approving the settlement agreement?
Well, they're different standards. The prudent standard is set forth in the statute, as we've talked about in 366.06.1. The public interest standard you all previously described in the Sierra Club as opaque, and it is not set forth by statute. It's determined on facts as they exist in individual cases.
Didn't we say though in the prior case that the public interest standard did encompass prudence review and included and incorporated it among other factors?
That it did not. You said that it did not encompass prudence, as I read it.
Didn't we discuss it as being inclusive of, among other things, the prudence standard?
I read your opinion that the question there was prudence needed to be conducted with respect to these peaker projects? And you all said no. Justice Lawson, you wrote a concurring opinion that said, well, if it's a big enough issue, maybe you should look at it under a prudence light. But that my reading of that was you did not say that prudence was part and parcel necessarily of the public interest standard.
Can something be in the public interest and imprudent at the same time?
I think it can, but I think that depends on the facts. And our chief complaint here is there's a rule that says you have a 15% reserve margin. And all of these projects were being added on to a reserve margin that was over 20%. So we just said, it's not needed. My client supports renewable energy at the right time if it's needed. And the way utility planning is supposed to work is you're supposed to bring utility power plants on to match a need, and it kind of evens out. But if you have a PSC rule at 15%, and then through this settlement, you're adding on top all of this new generation, the statute talks about used and useful. Ratepayers should not have to pay for projects that are not used and useful. And that's not to say what we're asking is that you send the case back to allow for us to make the argument that this is not needed for reliability purposes. The commission in their order on page 8 said the reliability for generation purposes argument is irrelevant. They didn't even consider it. They said it's irrelevant. So we think that was error not to consider the argument that you should at least take into consideration, is this needed? And we don't believe it is, and we think that we could demonstrate that, but we weren't given the opportunity because of the ruling that it was irrelevant. I'll reserve the remaining amount of my time if I could.
Good morning. May it please the court, I'm Adria Harper. I'm representing the Florida Public Service Commission, and I'm going to be splitting my time in half with Mr. Alvin Davis, who will be available to address questions for Florida Power and Light. We're here today, briefly. I'm going to get to a bit of the discussion that just occurred here, and I just want to point out that we're here today, in essence, relitigating an order, a final order that the Commission had approved quite a while ago, that this court has already reviewed and affirmed and found to be in the public interest. A final order on a settlement agreement that included 167 issues, including these solar projects. And to your point, they were specifically laid out, the capacity size in that settlement agreement, the capacity size and the procedure for how they would be approved, and the requirements for these solar projects. So they were not optional, as FIPUG tries to assert. They were part of that agreement, and the court referred to them several times in this opinion on this final order. So all of these arguments that FIPUG is making about capacity and need and reliability and all these things are irrelevant in an attempt to relitigate something that we've already been down before.
Was the argument that this capacity exceeded the necessary reserve capacity for the entire system and therefore wouldn't be prudent available at the time of the settlement agreement?
There was not an argument to that point.
Well, I know it wasn't made, but
Right.
would it have been available to a party if they wanted
Yes.
to challenge this on the grounds that, we were already above 15% reserve capacity in the system, and therefore adding 1,200 megawatts of solar to that would be imprudent? Would that have been an argument that would have been available?
Well, I think the standard we would look at is the cost effectiveness of that. And the record did show that there was a capacity need for these solar projects, even though that was not mandated by the criteria in the settlement agreement. I think the more appropriate time to ask that question would have been during the settlement proceedings, where the parties had ample opportunity to question all of those criteria: capacity, size, cost, all of those criteria. Okay. I'd also like to address just briefly the sitting back and waiting to appeal this, as I just sort of alluded to. All of these issues, because they were specifically mandated by the settlement agreement, it would have been more appropriate for them to be raised in. As you suggested, the Commission could have looked at these issues, whether prudence would have been included in the cost effectiveness standard or what have you. And so it's really unfair, because per the doctrine of administrative finality, we have parties that have relied on this and gone forward. The Commission has moved forward with this, and so that would have been the appropriate time to raise it. And so there was an opportunity for FIPUG to do it, and they chose not to.
I understand their position to be that there was really not an evaluation for need. What in the record and in the prior case, or in this record, in this case, supports the position that there was an analysis of the need for this project?
Well, there was record evidence and testimony from Mr. FPL witness, Mr. Enjamillo, who testified several times during cross-examination that was performed by FIPUG, that these projects did meet a capacity need. And so there's record evidence to support that. If there's no other questions, then I'm going to allow Mr. Davis to have his shot. Thank you so much.
Good morning, Alvin Davis on behalf of Florida Power and Light. I think the points that the justices have raised are the points that we raised in our opposition. I'd like to address the notion of why now and why not then, because there are two factual matters in the record that cause those questions to have particular import. The explanation in the reply brief as to why it wasn't raised then is because who knew that FPL was going to proceed with these solar projects? FPL, the largest producer of solar energy in the United States. The record in the case indicates that Chairman Brown, in the settlement hearing, specifically addressed the fact that these solar projects that we're dealing with here today were going forward. Not that they might sometime in the future, but that they were going forward. If you look at page 209 and 210 of the transcript of that hearing, the chairman said, these projects that are going forward are wonderful projects, ambitious projects, and made reference to the fact that all of these other projects of solar had gone forward by FPL. So the chairman commended, essentially, FPL for planning to proceed with these projects that are at issue here. The FPL witness in response said, yes, these projects that we are going to roll out, we are going to roll out, not that may happen sometime in the future, who would know, it's we are going to roll these out, are more ambitious than the projects that we rolled out in the past. So he makes reference to the prior projects, to these projects going forward, to point out that because they're doing more and larger projects, that the costs will go down even below the standard that was established in the settlement conference. So the fact that these projects we're talking about now were not just pie in the sky, but that everyone in that room, including FIPUG, knew that they were going forward is in this record. There is no doubt. So the explanation that we did nothing at the time because it wasn't ripe is simply incorrect based on this record. The second point, that FIPUG didn't know what standard would be applied, and therefore they are surprised that prudence wasn't applied, is equally unavailing. The standard was established in that settlement agreement. It said this will be the standard. The standard will be cost effectiveness. It didn't mention prudent. So they knew in 2016 when the standard was set, the standard that we met in this case, they knew that was going to be the standard. So the notion that they did nothing to raise this in the settlement in 2016 and 2017 does not make factual sense. So there is no basis for their having sat on their hands. There is this additional factual issue that the court, I believe, respectfully should consider. FIPUG entered into a settlement with TICO a month before the hearing on this settlement in this case. The TICO settlement, to which FIPUG was a signator, is identical to the settlement that they are challenging here in all material regards. That is, there was no prudent standard required in that settlement either. That settlement, in fact, made reference to the FPL settlement that took place prior. The settlement we're talking about here made reference to the fact that the TICO settlement is similar to the FPL settlement that established the standards that we're talking about today. If prudence wasn't required in TICO, and if FIPUG could sign on to that settlement, then what has changed? Either prudence is required, and they should not have agreed to a settlement that didn't require it, or prudence is not required, which we believe is the appropriate response here. There are these factual anomalies.
Can I ask you a question?
Of course.
So could you address, though, the fundamental point they're making that to the extent that there's a legal requirement that governs this, that you can't essentially agree in a settlement agreement to ignore the legal requirement? And it's not clear to me whether the argument here is that there's some aspect of prudence sort of baked in on the front end and that that's the way that you're complying with that, or is your position that you can agree to something in the settlement agreement that wouldn't comply with the law, and as long as nobody objects at the time, that's okay?
It is not our position that we can write around the law, no. The decision by this court that accepted the public interest standard for the settlement, I think as noted by the court, subsumed the issue of prudence.
So as Justice Luck was asking, I mean,
Yes.
Is that your argument, that the public interest review included some aspect of that?
It's my argument, and I believe that's the holding of the Sierra Club case.
Counselor, are you pointing to page 912 of the opinion, which stated that, quote, "The prudence of large and capital investments," like this one, "is a relevant consideration in the Commission's review of a settlement under its public interest standard because imprudent investments of millions of dollars would likely clash with a public interest finding"?
Yes, Your Honor. That would be the reference that I would make. Did that respond sufficiently to the question?
And isn't the argument the same argument that the Sierra Club made, and therefore was an argument that was available at the time? The Sierra Club came in and said, with the peaker projects, you should disapprove this because the commission in its final order didn't make a prudence finding with respect to these hundreds of millions of dollars. And our response was, you haven't established that it's not in the public interest, and prudence is a consideration. That argument could have been made with respect to this project. Sierra Club could have raised the issue, attempted to demonstrate the imprudence, and therefore why that portion of the settlement agreement was not in the public interest. Wasn't that available at the time?
It was, and there's no explanation why they didn't join in the appeal by the Sierra Club on the same basis. This SORA mechanism was approved at that time and was all a part. This is an issue that FIPUG does not address either. This court made a point of discussing the settlement as a resolution of 167 separate issues. Now, what FIPUG is proposing to do is to extract from that settlement of all those issues one issue that it could have raised then but did not for no reason. I mean, there's no explanation for not having raised it then. But now they want to pull it out and say, even though if we had raised it then, we would have lost that argument because the court said that prudence wasn't required. Now we want to raise it out of time as a separate point, even though we could have raised it then and didn't. So it's not a timely appeal on their part. The issue was resolved by this court. FPL is entitled to rely on that. That's the whole point of regulatory certainty. So we are here saying the court needs to affirm what was done. No other further questions? Thank you.
Thank you. Let me, if I could, the question you asked about, well, wasn't this argument available back at the time of the Sierra Club final order? I mean, you know, again, there are two distinct orders, as the record demonstrates clearly. One is a final order approving a settlement, and this is a final order on a rate application. And we're arguing the statute with respect to a rate application requires that there be a prudence review. But the argument about how much is in reserve is not an argument or factually one that's set in time. You know, this sober mechanism is a 4-year mechanism. It says up to 300 megawatts per year, and they come in and file. If facts on the ground change, someone should be able to come in and say, well, wait a minute, you don't need this slug in 2021 because your reserve margin is at 35%. You know, that's clearly not something that is needed for reliability purposes so that ratepayers have enough energy. And
I'll let you finish.
Well, I guess I was going to make the point that there's a rule on the 15% reserve margin, and FPL's witness admitted that rule was in place not only to make sure people have enough energy, but to make sure that the utilities don't overbuild and charge ratepayers for assets prematurely that are not used and useful. And that's what we're contending here, that this settlement agreement, there's never been a prudence review conducted on this nearly $1 billion. And if you take FPL's position, there won't be a prudence review conducted on any further
I'm
ones.
still struggling why these arguments you're making now would not have been arguments that would have properly been made in challenging the settlement agreement. And it seems like that ship has sailed, and if you wanted to make those arguments, that would have been the time to make them. And maybe they would have had merit, but they weren't made then.
If we had taken that up on appeal and filed a brief and said, we believe that the commission may not conduct a prudence review, notwithstanding their prior precedent in the GTE case, you know, what would they have said? No, we'll do it? I mean, it seems like that issue with respect, there's a statutory obligation to conduct a prudence review, and the settlement agreement gave no hint at all that the commission would not follow the statute and this court's directive and their precedent and not conduct a prudence review.
The settlement agreement said that in the fuel cost recovery docket, this review would happen and this would be the standard. I don't know what other notice you would need to know exactly what and when and in what proceeding the commission was going to determine these costs added to rate.
And it said, this is the process and this is the standard, A, B, and C. And A, B, and C were the three provisions that the parties crafted and put in the settlement agreement. It was silent with respect to what the legislature said, which was prudence. And we assumed that prudence, they would follow the statute. They're a state agency, all their powers derive from the legislature, and respectfully, we had no indication that they were not going to follow the prudence requirements until we were asking questions about reserve margin, and they said, well, you can't ask those questions because that's not part of the settlement agreement.
Let me ask you this different question, and that is, it didn't appear to me, so I'm curious, is it your theory, or was it your theory below, that circumstances have so changed since the testimony was taken and the settlement agreement was approved, that now we should consider something different? In other words, the projected demand for right now, when the settlement agreement was approved, was here, but the real demand is really here, and so changed circumstances are a reason why we need to address this issue that was resolved before.
Yeah, I mean, circumstances do change. I know with respect to administrative finality, if there's a dramatic change in circumstances, that gives you the ability to review it. But it was contemplated that it would be something that would evolve and move. And I guess the other point, with respect to saying, no, it's wrong, you're not here at the right time, you should have come in earlier, you know, that would have, in effect, presented